Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we picked up some of the important articles from the Hindu which are very significant for your UPSC and your KPSC examination point of view. Let's get started and look into the first article. The first article here is speaking about suspension of the members of the parliament. What is this article speaking about? The article here is speaking about that members of the parliament were suspended from the house of the parliament. It is in this particular backdrop we have to understand what is the procedure that is being followed for the suspension of the members of the house. It is in Lok Sabha or it can be in the Rajya Sabha. Why are these decisions taken by the respective presiding officers? What will be the conclusion when it comes to how the proceedings happen, and how is that this particular suspension can be revoked by the house? That is what will be the discussion point when it comes to the suspension of the members of the house. When it comes to the general rules that are being followed, why exactly suspension of the members happen? Let's say for example we have the house. Within the premises of the house, what we also have is the presiding officers who will be seated. Within the presiding officers, close by to the presiding officers, what you will also have is the members who will be seated here, and these members will ultimately be the treasury benches. Whenever you have the members of the parliament who will be seated in the house, they enter the well of the house, start creating ruckus in the house. They will be requested not to enter the well of the house despite making these attempts not to enter the well of the house. If the members so enter, that is when suspension can be initiated by the presiding officers of the house. Who are the presiding officers? When it comes to the Lok Sabha, it can be the speaker. If it is not the speaker, it can be the deputy speaker, and similarly if it is in the Rajya Sabha, it can be the chairman. If it is not, it can be the deputy chairman as well. So how will the members be suspended? The members will basically be asked not to enter the well of the house. Yes, they can voice out their concerns. They would be able to raise the voice against some of the important machines, some of the important mechanizations that have been happening in the country. If it feels that it is not listening, if the government is not listening, these members enter the well of the house, and when they are requested not to do so, if they continue to create the ruckus, the presiding officers will immediately issue the notice of suspension, and the same will be asked to be given to the Ministry of Parliamentary Affairs. The Ministry of Parliamentary Affairs takes note of it, and ultimately these members will be immediately be suspended. So in a major escalation of tension between the members of the opposition and the government, 78 MPs were suspended from both houses of parliament, taking the total number of suspended MPs in this session to 92. Opposition leaders termed it as a murder of democracy. So there were many people who were suspended, and as a result what we have to look into is with the procedure for the suspension of the members of the house. So what is the general procedure? The general procedure is that you have the members of the parliament. What is the role of the members of the parliament? The members of the parliament will basically cater to the audience, that is the constituency members. Let's say we take the constituency of Delhi North or Delhi South or Bengaluru North or Bengaluru South or Centre. In this particular case, there is an issue that is persisting. So what will an MP do? The MP will take up this particular matter, voice his opinion about this particular issue of his constituency in the parliament. What if he is not allowed to speak in the parliament? There has to be a designated time that has to be given to this member of the parliament despite request that is being made. What if he is not allowed to speak? So why will these issues surface? That is because when a person, that is the member of parliament, wants to speak and the parliamentary affairs committee does not allow this person to speak, so MPs do not have enough time to basically speak about the crucial matters. That is when these issues can surface. They may enter the well of the house, they may enter near the treasury benches as well, create a ruckus. In order to avoid it, that is when suspension can be taken up by the presiding officer. Or for example, there is an MP. The MP is making several requests to the government to speak about a particular subject matter. Despite giving number of petitions to speak about such a matter, the government has become unresponsive to it. In that case, these members create a ruckus in the well of the house so that they also know what is the issue that is persisting in their constituency. That is another part. Then there are also people who want to publicize themselves. There is publicity stunts as well, which is why they go about creating ruckus in the house. And at the same time, if the government fails to stop the proceedings, for example, these members start interrupting every now and then, and if these people are not stopped, that is when suspension proceedings will also be initiated. So it is the presiding officer who initiates this suspension of the members of the parliament, and he will also speak to the Ministry of Parliamentary Affairs and ultimately conclude with this entire process. What will be the terms of the suspension? Let's say, for example, there is an MP. This MP can be suspended for a day. This MP can be suspended for a week, or generally and a maximum, this MP can be suspended for the entire session, which means to say we have the monsoon session, we also have the winter session, we also have the budget session. If a person or an MP is not listening to the presiding officer, a warning will be issued. He can be suspended for a day, for a week, or for the entire session, which means it can be the budget session, it can be the winter session, or it can also be the monsoon session as well. So for all these three things, he can be suspended. So suspended members, once they are suspended, cannot enter the chamber, or they would not be able to attend the proceedings. They will not be able to issue notices to the parliamentary affairs meeting. They would not be able to make a request that I want to speak about something, and the parliamentary affairs may not pay heed to their request as well, and ultimately he loses the right to get a reply to his question that he has asked in the parliament. These are the various issues about the terms of the suspension. So what are the laws that we have? When it comes to the rules that we have the Rajya Sabha rules, we also have the Lok Sabha rules. When we speak about Rule 373 of the Rules of the Procedure and Conduct of Business, it says the Speaker, if he is of the opinion that the conduct of any member is grossly disorderly, may direct such member to withdraw immediately from the House, and any member so ordered to withdraw shall do so forthwith and shall remain absent during the remainder of the day's sitting, which means that he should be moving out for the rest of the day, which is what we just discussed. Rule 374 says Speaker may, if it deems necessary, name a member who disregards the authority of the chair or abuses the rules of the House by persistently and willfully obstructing the business. If a member is so named by the Speaker shall, on a motion being made forthwith, put the question that the member naming such member be suspended from the service of the House for a period not exceeding the remainder of the session. So the maximum that this person or an MP can be suspended is for the entire session. A member suspended under this rule shall forthwith withdraw from the precincts of the House. Rule 374A was incorporated in 2001. According to 374A, notwithstanding anything contained in 373 and 374, in the event of grave disorder occasioned by a member coming into the well of the House or abusing the rules of the House persistently and willfully obstructing its business by shouting slogans or otherwise, such member shall, on being named by the Speaker, stand automatically suspended from the service of the House for 5 consecutive sittings or the remainder of the session. So it can be 5 days, or it can also be the entire session as well. So what is the suspension period that he can maximum be suspended for? It is for the entire session. So the session is basically the winter session or the monsoon session or the budget session, so on and so forth. So the minute the Speaker is asking the member to withdraw, if he does not withdraw, he can be suspended for the rest of the period. Can court intervene in this particular backdrop? No. Article 122 of the Indian Constitution says that parliamentary proceedings cannot be questioned before a court. However, if they are suspended much beyond a session, in that case they can also go to the parliament as well. For example, in the state of Maharashtra, there were members who were suspended. So these members were suspended much beyond a particular session. As I told you, they can maximum be suspended for that particular session, but if it is much beyond that, in that case they would be able to go to the doors of the court and ultimately the judiciary will decide. So in the state of Maharashtra, when they were suspended much beyond a session, they appeared before the Supreme Court and the Supreme Court clarified that the maximum period for which they would be suspended is for the period of a session and not beyond that. These are some of the interventions that have happened from the court, but generally the courts will not interfere because Article 122 of the Indian Constitution says all the parliamentary proceedings cannot be questioned before the court of law. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says legislative decline. What is the legislative decline? Legislative decline in this article basically speaks about the deliberations and the discussions. What are the deliberations and the discussions? This article has a direct bearing to the previous article. So the article goes on to say that whenever an MP is elected, his major agenda is that he has to be accountable to the people of his constituency. And how is he going to be a representative of his constituency? If there is an issue that is persisting in his constituency, he obviously has to bring it before the parliament and ultimately ask the parliament to work about and create a solution for that particular problem. But in India, what we have is the political party based system. Some of the MPs may be given voice, some of the MPs may not be given voice. We also have the Parliamentary Affairs Ministry, which generally allows a person to speak in the parliament. But what if this person is not allowed to be spoken for a very long period of time? In that particular case, what would happen? This person would obviously want to vent out his anger, and he vehemently puts out his anger in the form of entering the well. This is where the article goes on to say that when it comes to the parliamentary affairs, when it comes to the parliamentary committees, these parliamentary affairs and the parliamentary committees will have to allow every single individual to voice out their concerns or problems with respect to the constituency or with respect to the general area of the entire country. If they are not allowed to do so, in that particular case, the very hallmark of the functioning democracy, which is deliberation, will be at stake. So the article goes on to say that as many as 78 opposition members of the parliament were suspended, 14 more were suspended earlier, 92 in total, and nearly matching 94 suspensions overall since 2014 prior to this session. So the article goes on to say that if at all there is a debate that has to be discussed, they have to be deliberated, there has to be discussion point about a particular matter. If the opposition political members are not allowed to speak, this could be the spate of the future deliberations and discussions. So the hallmark of functioning democracy is deliberation, wherein elected legislature debate and discuss issues of public import and seek solutions to the issues that affect the citizens. If they are not allowed to do so, if opposition is not allowed to speak, in that particular case, they will obviously start creating ruckus. They will not be allowed to speak. They will not be allowed to discuss on bills and legislations. This is against the proprietary and the principles of the parliamentary democracy, is what is this article all about. Now let's look into the next article. This article says a blow for the rights of the legislature in lawmaking. What is this article speaking about? The article here is speaking about the governor's power. We have the Supreme Court of India, which has recently clarified what are the powers of the governor of the state. When it comes to the governor under Article 163 of the Indian Constitution will have to listen to the aid and advice of the Council of Ministers. Yes, the governor does have the discretion, but this discretion does not mean that he supersedes the position of the Council of Ministers, where the Chief Minister is heading the Council of Ministers, which means that the governor is the executive head of the state, but ultimately it is the prevalence of the wordings of the Council of Ministers which will prevail over the governor. Why? That is because the governor is just the representative of the union government. The governor is just a spokesperson of the government, which means to say the spokesperson of the central government. He wears two hats, one of the central government, the other of the state government. So in case there is any vicissitude, attitudes, or the government is not working according to the constitutional principles and the ethos, that is when the governor can issue a fortnightly recommendation to the central government, to the president, and ultimately he is keeping a constant check about the activities of the state government. But in rest of the cases, it is the will of the Council of Ministers, which is headed by the Chief Minister, where the governor has to listen to. Why? That is because the governor is just appointed, but then when it comes to the Council of Ministers, they are elected. So the will of the people will prevail over the autocracy of the governor. What happens in most of the cases? Let's say, for example, there is a bill that is proposed by the state government. The Council of Ministers decide on a particular bill, and this bill will be proposed, and ultimately it will go to the governor for his assent. Because any bill to become an act, what we require is the permission and an assent and the consent of the governor. But what does the governor do in most of the situations? He may give assent to this particular bill, and at times he may not give assent to this bill. And the minute he does not give assent to this particular bill, he holds on to the bill. It ultimately culminates into that particular bill lasting with him for a very long period of time. Sometimes this also means it is called as a pocket veto. He does not respond to it, and ultimately this bill will fall flat. So you have number of constitutional thinkers who've gone ahead and said, like the commentators of provision like D.D. Basu, who have held the view of the governor's power to withhold the assent under this article has a finality about it, and once the assent is withheld, the bill will die a natural death. In order to clarify it, what we have is the Supreme Court of India, which has issued a clarification. The clarification is with respect to two subject matters. One is with respect to the governor holding on to the bill and the governor returning the bill for reconsideration, and with respect to he referring the bill to the presidential consideration. What if a bill has been proposed? It goes to the governor. So the governor ideally has to give assent to this particular bill. Does he have the power to hold on to this particular bill? He may, but the Supreme Court has clarified that if a bill has been given, this has to be decided by the governor as soon as possible. If it feels that there are some, let's say, provisions in the bill which is not right, he may ask the legislature, he may ask the executive to reconsider this proposal. However, if they send back the bill with amendments or without amendments, it is the right of the governor to give assent to the bill. He need not have to withhold the bill. So the Supreme Court has clarified that whenever a bill has been referred to the governor in all likelihood will have to sign this bill. He has to give assent to this bill. If he does not do so, if he returns it back to the legislative assembly, the legislative assembly with amendments or without amendments may send it back to governor. The governor has to compulsorily give assent to this bill, is the clarification given by the Supreme Court of India. This is one part. The second part is, whenever we have the governor, he may refer a bill to the President of India. Does it mean that it is the discretionary power of the governor where he refers all the bills to the President of India? No. When you look at the Constitution of India, when exactly can this bill be referred to the Supreme Court of India? Let's say to the President of India. Let's say, for example, there is a governor who feels that the powers of the High Court has been taken away by the executive and the legislature of a state. In that case, he may immediately propose this bill to the president. So we have the state government. The state government has proposed a bill where it is planning to snatch away, take away the powers of the High Court. In that case, because it is the state government is planning to snatch away, take away the powers of the High Court, he immediately references this bill to the president, and ultimately it is the Ministry of Home Affairs, the Union Cabinet and the president who will decide whether this particular bill of the state has to be executed or not. So in these circumstances and situations, it is 100% right for the governor to refer the bill to the president. But in rest of the other situations, it is the governor who has to comply by it. But do we have the provisional proprietary constitutional ethos being followed? No. Rest of the cases, even if it is a minute of a minor of a bills, even in that case, it is being referred to the president, and ultimately the president does not have any time bar prescribed, and he continues to keep this bill for a very long period of time, and ultimately this bill will not be implemented. So in this particular backdrop, the Supreme Court has once again clarified that if at all a bill is given for assent, they have to sign it as soon as possible, and only those bills which is going to change the character of the high courts, those will have to be referred to the president, and in rest of the cases it need not be referred to the president, says the Supreme Court of India. Then the second place where the constitution makes an indirect reference to the president's assent to a state bill is Article 254 of the Indian Constitution. Under clause 2 of the article, a state law, an item in the concurrent list, will prevail in the state even when it contains an existing repugnant to the provisions of an existing central law. What do we understand by this? Let's say, for example, we have one of the bills that is being proposed by the state government. So what does the state government do? The state government basically will come up with an act, will propose a bill. This bill is a concurrent subject. What is a concurrent subject? The state governments would be able to make the laws, and at the same time the union government would also be able to make the laws. For example, education is one such subject. What if the central government has decided on something? In that particular case, they have proposed a legislation and it has already been given permission by the president. It has already become an act. It is a concurrent matter subject. Now, what if there is a legislation which is in contradiction to the central law? What if the state government comes up with the legislation which is in conflict directly with this concurrent subject matter? In that particular case, he may refer a matter to the president's attent to a state bill. So if at all there is a conflict, even in that particular case, with the previous consent of the president, they would be able to rectify it. If the president does not give the permission, then whatever is given in the central law, that will prevail over the state law. These are some of the important parameters. Similarly, under Article 213, it deals with the ordinance making power of the governor. Under this provision, in certain cases, the governor can promulgate an ordinance only with the instruction from the president. That is, the governor can promulgate an ordinance only with the instruction from the president in a case where he would have deemed it necessary to reserve a bill obtaining the same provisions as in the ordinance. The words deemed it necessary indicate the making of judgment by the governor in terms of constitutional scheme of the power of legislative division. In other words, the governor cannot act on his whims while dealing it is necessary to reserve the bills, is the clarification that has been given. So the governor will ultimately have to cater to the government needs. The Council of Ministers advice headed by the Chief Minister and rest of it should not be referred to the president, is what is this article all about. Now let's look into the next article. This article says grassroots democracy as a bulwark against Maoists. What is this article speaking about? The article here is speaking about the recent elections that took place in the state of Chhattisgarh. Generally, when we speak about Chhattisgarh, one thing that resonates in our mind is with respect to the Maoist activity. Whenever we speak about the Maoist activities, they generally do not allow the people to vote in the elections. Why do they not allow people to vote in the elections? That is because they basically believe if people start exercising this right to vote, which happens to be a constitutional right, in that particular case, they will start mandating the things. They will start making sure that the representative that they want is ultimately elected, and these representatives or the Maoists will not be able to act against their own whims and fancies. So they do not want people to go against them. They do not want people to make sure that their movements are taken into consideration, and ultimately, in order to ensure that Maoist activities are not taking precedence over the value of votes and the constitutional paradigm, what this article says is that we have PSI, we have the Panchayat Extension to the Scheduled Areas Act, we also have other provisions in the 5th and 5th schedule. These will have to be implemented so that ultimately these directions of the Maoists can be suspended over a period of time. So what is this article speaking about? The article currently goes on to say that when it comes to the Maoist activities, it is decreasing over a period of time. Why? That is because the Maoist activities bases its arguments on the very premise that the government is not able to do effective things to the people of that particular state. For example, if the basic amenities are not provided, education, health and basic food items are not being given to the people, or they have a piece of land, this piece of land has been taken over by the government, by the bureaucratic nexus, by also crony capitalism. In that case, what would happen? These people are put in thoughts where they feel that the government is not working for them, and this ultimately means that the Maoists are able to influence a certain section of the people, so that these section of the people are pitted against the government. In order to prevent it, provide them the basic amenities. In order to prevent it, provide them the industrial factors. In order to make sure that these people do not take up arms against the state, provide them all the basic amenities. If these amenities are provided, we would be able to influence these people who are present in the rural level and also in the remote corners. And at the same time, whenever these are provided, there is also influence of the Maoists who tend to say that the government is not working for them, they have a hidden agenda, so on and so forth, and the Maoists try to influence. They do not allow the people to cast their votes as well. It is at this particular point the Maoists also run a parallel government which is called as the Jantana Sarkar, as they call it, which has no feet to stand on the mid and the long term. This aspect is more or less appreciated by the local tribal population, but perhaps the state has not been able to inspire them enough for various reasons, real or otherwise. So they try to influence, they ask the people not to vote, they do not want people to actually cast their vote, and ultimately they do not want people to exercise their constitutional right. But this article goes on to say, despite all the pressures that have been put by the Maoists, people would want to vote primarily because they have been the beneficiaries of the government schemes and programs. This should continue to go on. As they continue to go on, as we increase the amenities that are provided to the people, these Maoists would not be able to influence the tribal people, says this article. Further, what we have is the Panchayat Extension to the Scheduled Areas Act. These modalities will have to be increased. So whenever there is a specific act which is giving them a right. What is a right? A right is something which I am entitled to. For example, under the right to health, I should be provided the basic amenities in a hospital, or under the Right to Food Security Act, I should be provided the basic amount of food which I would be able to collect from the public distribution system. So this is a right. So it is a something which I am entitled to. So what is a right-based approach? A right-based approach is the state has given me some right which I am entitled to, and this right has to be given to me by the state. So I'm exercising my right and I'm keeping the state accountable for such an action. So PSI is one such act, so which basically allows to provide me certain rights. If I can pick up these rights and if the government can execute these rights, give them a certain autonomy, this will allow them to mushroom and open up and paint a bluer canvas, a larger canvas of serenity and ultimately accountability is what is this article all about. Now let's look into the next article. This article says PMLA accused can be given copy of grounds of detention within 24 hours, says the Supreme Court. What is the PMLA? This is about the Money Laundering Act. The Money Laundering Act is where there is a certain amount of money which is illegally garnered. Let's say, for example, there is a crime syndicate. This crime syndicate gets the money from conducting the crime. So it is the black money. So what do? They make sure that this money is laundered and is converted into the white money. So basically, Prevention of the Money Laundering Act basically says that the money is laundered, and as a result of which it is converted into white money, legal money. To prevent it, what we have is the Prevention of the Money Laundering Act. The Prevention of Money Laundering Act basically wants to prevent the money laundering. So if any person person is involved in money laundering, earlier they were not, if at all they were arrested, they were not given any papers or they were not given any oral submissions as to why they were arrested. The reasons for their detention was not given. Now the Supreme Court has clarified that in a judgment that Enforcement Directorate need to furnish accused under the Prevention of Money Laundering Act with a copy of grounds of detention at the time of his arrest. The bench headed by Justice Bela Trivedi held that the written communication of the grounds of arrest need to be provided only within a reasonable period of arrest, that is within 24 hours, said the Supreme Court of India. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says NGT questions Tamil Nadu government on how oil spill reached PUlicat. This article here is speaking about the recent oil spill that occurred in the state of Tamil Nadu, and whenever there is oil spill, what are the likely consequences that it will result in? This will usually affect the animals, this will affect the species that are present, and ultimately this could also lead to death of these species as well. So in general, oil spills can affect the animals and plants in two ways: from the oil spill itself and from the response or the cleanup operations. So the minute there is oil spill, it immediately ensures that there is dwindling numbers because these species start consuming the oil, and at the same time the plants which are present are also killed in this particular process. The spilled oil can harm living things because its chemical composition are poisonous. This can affect organisms from the internal exposure to oil through ingestion or inhalation, and from external exposure through skin and the eye irritation. What creatures are most affected by the oil spills? Since most oil floats, the creatures most affected by oil are animals like sea otters, sea birds that are found on the surface or on the shorelines. Seabirds are harmed and killed in greater numbers than other kinds of species. Sea otters can usually be harmed by oil since their ability to stay warm depends on the fur remaining clean. What measures are taken when an animal comes in contact with the oil? Most states have regulations. Untrained people could not try to capture any oil bird. What type of spilled oil causes the most harm? This type of oil spill matters because different types of oil behave differently, and as a result, first we should distinguish between light and heavy oils. Fuel oils such as gasoline, diesel fuel are called as light oils. Light oils are very volatile, and if they spread out on the water as they do, when they accidentally spill, they will evaporate relatively quickly, and whenever this oil is also mixed with the fire, there can be fire which catches up, and immediately this can also lead to disaster consequences as well. So this article goes on to say that we have oil spill that has taken place in this part. How has it reached the PUlicat? Asks the National Green Tribunal. It is in this particular backdrop this article is being discussed. Now let's look into the next article. This article here is speaking about the Telecommunication Bill. The Telecommunication Bill is one of the important bills that we have. This article will not be discussed for now. I'll release an independent video where I can explain you every single provision of this telecommunications bill. As of now, let's keep it aside. Let's take this article in an elaborate way where I would discuss about every nitty-gritties of this provision. So as of now, we will not discuss it, but in the near future, we will take up this article in an elaborate way. It is this that we have to understand with respect to this article. So this is it for today. Thank you for watching. All the best.